The Honorable, the Supreme Court.
Good morning, everyone. Thanks very much. Please be seated. And go ahead and call the case.
Good morning, Your Honors. The matter before the court this morning is a case entitled Ivo Skoric v. Department of Labor, case number 23 AP 389. Appellant Ivo Skoric is self-represented. Seated at counsel table with Ivo Skoric is representing Amicus Curiae ACLU Foundation of Vermont, Attorney Harrison Stark. Representing the appellee, Department of Labor, is Attorney Jerry Adler. Seated at counsel table with Attorney Adler is Attorney Robert Depper.
Okay, thank you very much. Mr. Skoric, am I pronouncing it correctly? Yes. Come on up to the podium if you would, please. And you understand you've got 15 minutes, sir?
Yes.
And the light, we're going to give you a warning. What time?
At 8 minutes remaining.
At 8 minutes remaining, okay? You understand that there are two lights on that podium, so
Yeah.
keep your eyes peeled there.
I will.
All right. So please go ahead. If you would, identify yourself for the record.
Yes.
We're recording this, so
Yeah.
please identify yourself for the record and then go ahead.
Good morning, Your Honors. May it please the court. My name is Ivo Skoric, and I'm appearing pro se. I would like to say a few words before the amici address the statutory arguments presented in my appeal. I'm a 59-year-old, legal and responsible, prescribed medical cannabis user in the state of Vermont. I have an artificial knee, artificial hip, partially torn Achilles, reconstructed shoulder, fused cervical vertebrae, triangular fibrocartilage complex wrist injury, bipolar depression, post-traumatic stress from the time I was a distant former Yugoslavia, and chronic osteoarthritic pain overall. I am legally prescribed medicine for chronic pain by a doctor in Vermont, which I take as prescribed to improve my life and my ability to work. My work performance is excellent and in no detectable way negatively impacted by that medicine. I'm not impaired nor lacking performance within my therapeutic dosage. Yet, I was terminated from my job in the garage at the Marble Valley Transit Authority in Rutland, Vermont, where I was proudly working hard cleaning and fueling city buses after a random urine drug test that came back positive for marijuana. The employer indicated that they would rather keep me, being short-staffed already, but that their hand is forced by the Federal Department of Transportation rules.
Mr. Skoric, may I interrupt you and ask a question?
Yes,
Do you also drive buses?
my job was to park the buses in the yard.
So you would,
I would put them drive them in the garage, clean them, and then drive them in the yard.
were you required to have a special license for that?
I had CDL, yeah,
Okay.
CDLB.
Thank
But no passengers, sir. You didn't carry.
No, I wasn't driving the passengers, yeah. I was driving an empty bus between the garage and the parking lot. I was strictly using my medicine off duty, but the state still uses urine test as the gold standard, despite that it is a widely accepted scientific fact available on the Center for Disease Control website that cannabis is detectable in urine days or in more frequent users weeks after cannabis has any active impact on the user, which makes urine testing for cannabis meaningless and irrelevant as a proof of being under the influence of it. The country is currently slowly progressing towards the removal of cannabis from Schedule 1. Department of Health and Human Services under the Biden administration requested the review, and the Drug Enforcement Agency signaled its willingness to reschedule just last month. Vermont is one of 24 states where cannabis is sold legally, and one of 38 that recognized its medical value. 38 states.
Mr. Skoric, I'd like to ask you a question. I'm just going to change the topic for a moment. Can you tell me, are you asking this court to review the decision by the board that was issued on October 18th or October 27th? or both?
It is the October 27th.
And that's the one where the board decided not to issue a declaratory judgment, right?
Yes.
Okay.
In any functional federation, that would be a federal law. Because 3/4 of the union already recognize that there is a medicinal value in cannabis. But unfortunately, the federal law still claims cannabis has no medical use and has a high potential for abuse, which in my view is a belief rooted in nothing more than the past racial prejudice of Anslinger's reefer madness era and the political inertia to change it. Even though I was terminated solely because my employer had the peculiar obligation to follow the federal rules, which unlike the state law do not recognize my medicine as a medicine, in its initial determination, the Vermont Department of Labor characterized my termination as a termination for misconduct and disqualified me for 10 weeks. I believed that was wrong. As a medicinal cannabis patient in Vermont, to treat disabling conditions under the Vermont's Fair Employment Practices Act disability provisions, I should be protected by state agencies. I should not be disqualified from receiving unemployment. Medical cannabis law is a dead letter on paper, and the medical card is worthless if it renders the patient unable to receive benefits. Sadly, the state did little for 20 years following the legalization of medical use to prevent discrimination against patients in the workplace. Cannabis is obviously not at all treated as other psychoactive medications, like Prozac or risperidone, for example. A fear and a stigma plaguing it have no basis in science, but only in prejudice. This is why I petitioned for a declaratory ruling that would serve to clarify the present state legislation by making clear, as the law says, that cannabis users should not be penalized or sanctioned by the state for using medicine that the state itself has made legal.
Can I ask you another question? Refresh my memory. Did you start the job and then receive your medical marijuana
No,
card, or you had the
I
card
already
and
had.
accepted the job?
I had it.
Okay, thank you.
Sir, would you agree that consumption of marijuana while working would be a violation?
Well, I said I was doing it off duty.
No, if you're working and you're on a break and you consume.
Yeah, I didn't do that, but you know.
No, I'm just saying, would you agree that that would be,
This is out of the scope of this case, I guess.
all right, thank you.
Good answer.
This is why I petition for a declaratory ruling that will serve to clarify the present state legislation, making clear, as the law says, that cannabis users should not be penalized or sanctioned by the state for using medicine that the state itself had made legal. When the state passed comprehensive legislation around cannabis, it specifically said that cannabis users are protected from penalties or sanctions. The state, which collected almost $14 million in cannabis excise taxes in 2023, sure does not want to judge a person's eligibility for benefits based on the contents of their bladder. My position is that the off-duty use of cannabis for state-sanctioned medical purposes cannot and should not be qualified as a misconduct by the state. This is why I asked for the Rule 1 appeal, which the Employment Security Board never properly docketed, granting to me only the right to appeal their decision under the Rule 15. I should not have to choose between the state benefits and the medical care state granted me to use. I should never be put in that impossible position to choose between benefits and the legal medicine I use. Thank you.
Thank you very much. How much time does amicus counsel have now?
6 minutes and 57 seconds, Your Honor.
All right, counsel, please identify yourself and your client and go.
Thank you, Mr. Chief Justice. Good morning, Your Honors. May it please the court. Harrison Stark, he, him, on behalf of AMICI, the American Civil Liberties Union of Vermont, Vermonters for Criminal Justice Reform, and Disability Rights Vermont. We appreciate the opportunity to appear before the court today. Your Honors, as you just heard from Mr. Skoric, the Department of Labor denied him a portion of his unemployment benefits because it concluded that, and I quote, the off-duty use of medical cannabis, quote, requires disqualification of benefits so long as it violates an employer's policy. Amici have asked to appear today because that conclusion was in error for two principal reasons. First, although cannabis remains federally illegal, Vermont has comprehensively legalized cannabis here in the state, and the legislature has made it clear its intent to maximally insulate Vermonters from state penalties for their authorized cannabis use. Specifically, 18 VSA section 4230A directs that Vermonters may not be penalized or sanctioned in any manner, nor denied any right or privilege under state law. The denial of unemployment benefits is a denial of right and privilege under state law. And while the statute contains certain carve-outs for particular types of cannabis use that can still carry penalties, such as using in violation of a lease agreement, using while operating a motor vehicle, or to your question, Justice Cohen, violating an employer's policy about on-the-job use in the workplace, nothing in the statute authorizes the denial of benefits for off-duty use of medical cannabis.
What about a business like this, though, that has to follow federal law and not allow individuals who have this in their system to be able to do what the appellant here does for work? Even though Vermont has legalized marijuana, what is a business like this supposed to do in that event?
So 2 points, Your Honor. The first is that the business is still entitled to terminate an individual like Mr. Skoric. And Mr. Skoric is not, as I understand, challenging the termination itself. The business still has to follow federal law. I do agree that there is an element of unfairness in penalizing the employer in some way. But because the legislature has set this up to be zero sum, I think there's an element of unfairness however the court rules here. And for several reasons, it would be more unfair to penalize an individual like Mr. Skoric than to penalize the employer. And I think 2 points are important to note. The first is that while an employer would, of course, like to avoid a change in its experience rating, my understanding is that the relative risk to a change in its tax rate from a single discharge like this is relatively low. On the other hand, denying an individual who has just lost their job unemployment benefits because they used a state-sanctioned medicine is quite severe. Second, I think it's important to note that Mr. Skoric himself recognized the unfairness of the employer, and that was part of his motivation for seeking a Rule 1 declaratory petition. In his May 24th, 2023 petition for declaratory ruling, he recognized that his employer's hands were tied and he didn't want his employer to be penalized.
But Mr. Stark, I noticed that in your brief, your amicus brief, you didn't address any procedural issues, just the merits. So because you just raised the declaratory ruling issue, I want to ask you first, does this court have jurisdiction? Is this appeal timely filed? Because Mr. Skoric has indicated that he is appealing the October 27th ruling, which was the denial of the declaratory ruling by the board. And the October 18th motion for reconsideration was also denied. And when the board denied the declaratory ruling, their position was the September 11th order of the board, which was then denied on the motion for reconsideration on October 18th, addressed the same issues in the declaratory ruling that where the board denied issuing that ruling because those issues have been addressed in the live controversy below. So what is your position on that?
Thank you. You're correct that we did not brief this issue, but I'm happy to address it. We believe this court does have jurisdiction. Mr. Skoric filed his appeal within 30 days of the department's final response to his Rule 1 petition, which is what he asked for.
What date is that you're using?
October 27th. And so Mr. Skoric, as I understand it, mailed his appeal on November 16th, and it reached the department on November 20th. So it's within 30 days. You're absolutely correct that the legal conclusion that Mr. Skoric is challenging here remained consistent, whichever ruling the court looks at. So the department's conclusion that the off-duty use of medical cannabis standing alone constitutes misconduct, so long as it violates the employer's policy, that reasoning undergirded the initial Rule 15 ruling. The department explicitly reiterated it in its denial for his motion for reconsideration, and then it reiterated it again in its response to the Rule 1 petition on October 27th. So whichever way the court looks at it, that legal ruling has reached the court within 30 days. The court has jurisdiction to consider it.
Thank you.
Very briefly, Your Honor, I just want to move through Section 4230A. So Section 4230A provides that Vermonters shall not be penalized or sanctioned in any manner by the state or its political subdivisions or denied any right or privilege under state law for the use of cannabis. The denial of unemployment benefits is a right or privilege under state law. I think the best case for that is probably Langlois versus Department of Employment and Training, which is 149 BT 498. It's a 1988 case where this court addressed the due process protections that attach to unemployment benefits. And importantly, Section 4230A specifies a number of particular uses or contexts for consumption of cannabis where individuals may still be penalized. And so if you looked at B2, for example, that includes the operation of a motor vehicle. It includes the use of cannabis in violation of a lease agreement, or the use of cannabis on prohibited public property. And Section E, subsection E of the statute, addresses a number of employment-specific situations, including the use of cannabis in the workplace or on the employer's premises. But none of these, importantly, speak to whether or not an individual, authorize a penalty or sanction or denial of a right or privilege for the off-duty use of medical cannabis. And I think there's a good reason. I see my time is expiring, Your Honors.
Well, finish your thought. Go ahead.
This statute was passed as part of the comprehensive legalization package, two statutes that created a recreational market, but importantly, also replaced what was the dedicated therapeutic cannabis statute. And to the extent that therapeutic cannabis users in Vermont are insulated from penalty or sanction, this is the statute that does it. And I think it would be particularly nonsensical, just speaking to the department's argument about possession versus use, if the legislature were to say therapeutic cannabis users like Mr. Skoric may possess cannabis without penalty, but as soon as they use it, they're open to sanction.
Okay. Thank you very much. Your time has expired. So we'll hear from counsel for the appellee, please. Are you dividing time?
Yes.
Okay. Please introduce yourself and identify your client for the record.
Thank you. Good morning, Your Honors. Jared Adler, representing the Vermont Department of Labor. May it please the court.
Thank you.
This is a case about an employee's informed decision to violate his employer's workplace safety policies. The court should affirm the decision of the Employment Security Board that appellant was discharged for misconduct connected with his work for two reasons. First, because he was discharged from his safety-sensitive position for violating an acknowledged workplace safety policy. And second, because Vermont's drug code does not guarantee unemployment benefits to individuals who test positive on an employment drug screen. So first, I just like to address the issue of the declaratory ruling and some of the procedural issues in this case as they came up in the appellant's argument. So the appellant indicated that he's confining his appeal today to an appeal of the Employment Security Board's decision for his Rule 1A petition to issue a declaratory ruling. So if we look at Rule 1A, it states that the board must either issue a declaratory ruling, inform the petitioner that no ruling will issue, or hold a hearing. Here, the appellant issued his petition to the board, and the board responded to his petition, informing him that they would not be issuing a declaratory ruling. So arguably, this issue is moved before the court because the rights afforded by that Rule 1A petition have been satisfied. So there's no live issue under Rule 1A before the court today.
Mr. Adler, does it matter if, is there a distinction in your mind between consumption and impairment?
I think, Your Honor, that there is a distinction between consumption and impairment. However, when we're looking at the context of cannabis here, there's no clean way for an employer in this instance to sort of distinguish between consumption and impairment, because obviously cannabis is different from other drugs, and that it can persist in an individual system after they've consumed it. And so I think there's kind of a balancing test that needs to be considered. We're trying to protect the public and protect the employer's need to conform their policies with federal law.
So an employee who after work goes home and has a beer or two or three and gets impaired, but that's out of the system when that employee goes to work in the morning, even that would not have any effect on their employment. But a person who consumes marijuana potentially stays in their system for a longer period of time and tests positive, that would require it. Should those be distinguished?
Yes, I think, the two substances need to be distinguished. And unfortunately, it's just a fact that, and I think it was a huge focus of some of the amendments recently in 2017 and 2018 when the legislature was looking at amending the cannabis code about how do we balance the need for making sure that people aren't impaired when they're driving? How do we sort of provide law enforcement, for example, with the tools that they need to test individuals to make sure that if they test positive, that they're actually impaired. And from my understanding, the legislature was not able to really arrive at a scientific sort of answer for how do we resolve this issue. And so there's obviously this tension here where the employer, they need to sort of protect their really important interests here. They have an interest in maintaining federal funding, and they have an interest in having workplace safety and public safety in mind when they're implementing these policies. And if you look at the appellant's notice of appeal from his original determination, he acknowledges that the employer received up to 60% of their total funding for their business from federal grants. So there was a supremely important interest of the employer to make sure that they were adhering to these federal rules to the letter, and they didn't want to risk 60% of their revenue by sort of loosening their adherence to some of these federal rules. And so here, when we're thinking about misconduct, the standard that we're trying to apply is whether the employee exhibited a willful or culpably negligent substantial disregard of the employer's interest. And so I just want to kind of address one of the points made by Amici in their brief. And so they argued that the Porter case from 1981, that establishes that an employee's conduct needs to be intentional in order to satisfy a disqualifying misconduct. And I think that misstates the court's current understanding of misconduct. So in 1989, there was another case, Favreau, the Department of Employment and Training, and that case stood for the principle that an employee's conduct does not need to be intentional in order to be disqualifying misconduct. I think the intentional component points to willful conduct, whereas culpably negligent is the other possible way of an employee to satisfy a misconduct.
Is substantial disregard also another way to satisfy the misconduct?
I think the way it works is that you need to have sort of, you look at the employee first, and that's either their willful conduct or culpably negligent conduct. And then there's substantial disregard is how does that conduct impact the employer? And then you turn to the employer and look at the employer's interest.
And that can become misconduct though, right?
Correct.
Thanks.
Mr. Adler, if I could take you back to something you said about federal funding. Isn't there, well, of course, in our Constitution, our legislature is given the authority, the power to pass law. Why is it that to the extent that our state's legislature, through its duly elected representatives, pass laws that say one thing, that don't take precedence over what the federal rules are that may call for the impediment to federal funding? Why would that be? Is there authority you could cite for that?
I don't know if I have a specific citation for that authority, sir. I mean, there's certainly, federalism and states' rights issues to consider here.
That's a big topic.
It is,
these
it's a
days.
very big topic.
It's a big topic on a lot of different issues these days. And that's one of the reasons I'm asking this question, because it seems to me that a lot of the trend in the federal appellate level is towards giving states a greater expanse of authority to make their own decisions about these sorts of social questions.
Certainly, certainly. And so I'd like to look at the state law at issue here that was raised by Amici in their brief, which is 18 VSA 4230A. And I think it's very important to actually cite the text of the statute here when we're discussing how that applies to this specific instance. So 18 VSA 4230A A1, and I'm just going to quote the statute, except as otherwise provided in this section, a person 21 years of age or older who possesses 1 ounce or less of cannabis or 5 grams or less of hashish and 2 mature cannabis plants or fewer, or 4 immature cannabis plants or fewer, or who possesses paraphernalia for cannabis shall not be penalized or sanctioned in any manner by the state or any of its political subdivisions or deny any right or privilege under state law. So I think Amici's argument focuses on the second half of that statute, where individuals should not be denied any rights or privileges under state law. However, it's really important to take the context of the statute as a whole.
Doesn't the statute deal with possession, not use?
100%, yes, it does deal with possession only, and it's the section title is cannabis possession by a person 21 years of age or older. So I think the statute itself is actually quite narrow in its immunity. It doesn't apply to individuals where here he wasn't terminated from his position because he possessed cannabis or because he had paraphernalia on him when he was at work or elsewhere. He was terminated because he violated an acknowledged workplace safety policy. And they cite a statute and a case from the Michigan Court of Appeals that interprets a Michigan state statute in order to suggest that the same principle should be applied in Vermont. But if you look at the Michigan statute, it's actually quite a bit broader than the Vermont statute. So,
Mr. Adler, that's the decriminalizing of marijuana in the state of Vermont for an ounce or less in possession. But the appellant here has a medical card for medical marijuana. Is there a difference?
I think there is a difference. I think if the legislature wanted to insulate individuals who possess cannabis cards from any denial of a right or privilege under state law, then they would have need to have stated so when they amended the statute most recently, I believe in 2018. So if we look at the Michigan statute, for example, as an example, that states a qualifying patient who has been issued and possesses a registry identification card is not subject to arrest, prosecution, or penalty in any manner or denied any right or privilege. So that explicitly acknowledges that there's a medical cannabis program in the state and that legal consequences can flow from an individual's participation in that program. And that as a state, the legislature decided as policy that it would insulate those individuals from denials of rights or benefits. And so the Michigan court who was interpreting that statute as it applied in a very similar fact pattern said the legislature has spoken clearly and stated that individuals who participate in the medical marijuana program in Michigan shall not be denied unemployment benefits where their participation in that program has the result of having them lose their job. So here, the Vermont statute is quite a bit narrower. It doesn't have that explicit language that individuals who participate in the medical marijuana program are protected from a denial of rights or benefits. And so if that was going to be the outcome from looking at that statute, then the legislature would need to state it more clearly than it's currently stated, because as it's stated now, it's quite narrow. And Amici references 4230A subsection E, which outlines a number of exemptions from its immunity provision. And I think this list is meant to be non-exhaustive. These aren't the only instances in which an individual can be punished. It's outlining some of the policies of the state where they want to explicitly carve out from its immunity that individuals who are impaired while they're driving, individuals who use cannabis in the workplace shall not be arrested or penalized.
You cite 4230A B, is that what you said?
E?
E.
Yes.
What about A1?
A1, so 4230A1 is what we were just discussing. So this is the quite narrow immunity provision. And so the immunity provision applies only to people who possess cannabis under certain amounts.
Yeah.
Thank you, sir.
All right.
And that provision that the Chief Justice just referenced was already considered by the board in the live appeal. Is that correct? The off-duty use or or maybe whether the conduct of the appellant qualified as misconduct because of the no disregard.
Correct. So they found that this was a misconduct termination, and they didn't specifically address 4230A in their decision. However, their sort of omission implies that it does not apply in this case. So at this time, I think if there are no further questions, I can conclude my argument. Thank you very much, Your Honors.
Okay. Thank you, sir. Thank you very much. Does the appellant have time?
The appellant has no time remaining, Your Honor.
Okay, thank you all. Please